Can a country club enter an agreement to give members the rights to use a boat slip and then revoke it later? To find out, you have to read Skaneateles Country Club versus Cambs, but it's 16 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Skaneateles Country Club versus Cambs. The citation for this case is 2023 New York Slip Opinion 05352, published by the New York Court of Appeals on October 24th of 2023. The issue in this case is whether a license allowing the use of a boat slip is revocable at will by a country club. To understand and appreciate the context of this case, I think that this case is best understood when you get a little bit of an understanding of what a license is versus a lease. A license versus a lease. A license is permission, a privilege to do a given act at a given location owned by somebody else. So if you let somebody climb your tree, you give them license to do that, that is permission that is revocable at will by the owner of the property, by the person who has the interest in the real property. They can then say, you're not allowed to climb my tree anymore. That's revoking the license that you've given. So a license is generally revocable. It's also not transferable. You can't say, well, you gave me permission to climb your tree, so I'm going to give it to my friend John. That's what a license is versus a lease. A lease, on the other hand, is an exclusive use. It's an interest in real property. It's the person with the lease has exclusive use and rights to that particular plot of land. So if you lease an apartment, you can exclude anybody from that apartment. You don't own the property, but you have a right to exclusive use and enjoyment of that property. And a lease theoretically could be transferable. You could say, well, I've leased it and I'm going to give my interest in real property to my friend John. I'm going to sell it to him for $5. And a lease is generally not revocable. Okay, so that's lease versus license. So what do we have here? The facts of this case are that in 1999, the Skaneateles is a town in upstate New York. It's by the Finger Lakes region. Skaneateles Country Club developed a project to construct 80 boat slips on the Skaneateles Lake for the benefit of club members of the Skaneateles Country Club. Interested club members would have to pay an initial capitalization payment, $5,000, and enter into what they called an assignment agreement. That was the term, an assignment agreement. Olivia Cambs, who's the respondent in this case, the defendant, was a member of the Skaneateles Country Club. She was one of those original 80 people. In the agreement that she signed with Skaneateles Country Club, the SCC, I'm going to call it that from now on, the Skaneateles Country Club, agreed to assign and transfer to her, to Cambs, the use and occupancy rights with respect to one boat slip, subject to certain conditions. They also reserved the right to determine the specific boat slip she would get, and she, Cambs, would have the right to transfer that boat slip as a legacy to her offspring if certain conditions were met. She agreed to pay all the fees, maintenance fees, annual fees, and obey all the rules. The agreement stated that if Cambs elected to terminate the agreement or was no longer a club member, SCC would have to return the initial capitalization payment, that $5,000. So what do we have here? What happens then is SCC and Cambs, unrelated to the boat slip, have a disagreement, a dispute about her payments as a country club member. She found out that another member had sued them, got into a dispute because they had overcharged on certain member issues with the club. So she contacted them and said, hey, I want my money too because you've been overcharging us members. And they say, oh yeah? Well, we're revoking your boat slip license. They go to court to try to have a court declare that it's a license that is revocable. The Supreme Court grants that motion. They grant the application by SCC for summary judgment saying it's a revocable license and it's revoked. It goes to the appellate division. The appellate division reverses and they say it's a license, but there's certain things that can happen in the license that make it irrevocable. And it goes to the Court of Appeals. And that's what we have here. At the Court of Appeals, we have a majority and a dissent, a 5-person majority decision with a 2-person dissent. At the Court of Appeals, the majority says, listen, everyone here agrees at oral argument and in papers that this was a license. The only question was whether the SCC had the ability to revoke it at will. And the holding says the general rule is that licenses are revocable at will. There are a few exceptions to that, but they don't apply here. And because they don't apply, the general rule that it's revocable at will holds. Therefore, it's revocable at will, and the SEC can revoke it at will. That's the majority holding. But we have a very interesting dissent here by Judge Rivera, joined by Judge Wilson. And they say, I don't care what the parties say at the oral argument. I don't care what they put in papers. What controls here, what we have to look at is the agreement. And what the agreement says is it gives exclusive use and enjoyment to a specific property. And it gives it's transferable. So I don't care if you call it a license. What that is a lease. She doesn't use the word lease, but she says this is granting exclusive use control. That's not a license. So if it's not a license and it's a lease, it's not revocable at will. But she says even if you consider it a license, there are exceptions that make a license irrevocable. Some exceptions are if the licensor acts in bad faith, if it's coupled with an interest in property, if it's made irrevocable by contract, or if there's a financial investment by the licensee. And here we have those things. In particular, they say Cambs bought a boat to put in the slip. When that boat burned to the ground, she bought another boat to put in the slip. She paid all these fees over the years for the last 25 years. This is an irrevocable license if you consider it a license. But once again, the majority holding is that it is a license and it is revocable generally, and that's the general rule. And that holds here. So that's the case of Skaneateles Country Club versus Cambs. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.